Jury is back in the courtroom. Welcome back, members of the jury. Mr. Bruckler, you want to proceed with your direct examination of Dr. Reed?
Yes, Your Honor, I do.
All right, Dr. Reed, I remind you that you're still under oath.
Yes, sir.
And then I want to remind the jury that the court has admitted the testimony of Dr. Reed only for a limited purpose. You may consider this testimony only as to the issues raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this evidence for any other purpose. Mr. Bruckler, you may proceed.
Thank you, Your Honor. Doctor, we were talking about schizotypal personality disorder and some of the diagnostic criteria. What I want to ask you is, in terms of the serious mental illnesses that there are, is schizotypal one of them?
Yes.
What percentage of the population has a serious mental illness?
Objection. Relevance?
Sustained.
Doctor, is one of the hallmarks of schizotypal personality disorder...
Actually, let me back up.
Yes, sir.
I will overrule myself. Overruled.
Yes, sir.
The objection is overruled. Go ahead.
Did you know that question that I asked before?
Yes. What percentage of the population has a serious mental illness?
Yes, sir.
What I would consider to be a serious mental illness, or what various professional groups consider something called severe and chronic mental illness, give or take altogether 3 to 5% of the population.
3 to 5% of the population?
3 to 5%.
Across the planet or in the United States, or does it
At least in the United States, and most conditions are not limited to any particular cultural group or gender or race.
Is it the hallmark of a serious mental illness that someone is violent or prone to murder?
No, not at all.
How about schizotypal personality disorder specifically?
Not at all. Murder and serious crime violence is quite uncommon.
How about, well, let's go to one extreme. How about schizophrenia?
It's quite uncommon.
I want to ask you if you formed an opinion as to whether or not the defendant was floridly psychotic or suffered some psychotic break on July 19th and or 20th of 2012.
Objection asked and answered.
Overruled.
Yes, I have an opinion.
Tell us about it.
My opinion is that there is no indication at all that I know of that Mr. Holmes was, I'm going to use the phrase, floridly psychotic on July 19 or 20. What I mean by floridly psychotic, I guess it's a term of psychiatrists and psychologists. The psychosis or the break with reality is very evident. I mean, I guess think of a flower that's completely there in all its color. I have no indication at all that he was anything like that at any time on July 19 or 20.
In coming up with your opinion as to whether or not the defendant had the capacity to know right from wrong based on social standards of morality, tell us what things you considered and factored into that opinion.
If I may, I'll refer to my report.
Yeah, and would it refresh your recollection to go through those things and tell us?
I outlined them in a good way, I think, of thinking about it in the report relatively quickly.
What page are you on, Doctor?
I'm on page 3 through 5.
Doctor, forgive me. Can I, now that I've got you right there, can I back up 1 second?
Sure.
I was just reminded I didn't follow up on something. We talked about florid psychosis, and you do not believe that the defendant was floridly psychotic back when these murders were committed. Is that different than a psychotic break?
One can have a psychotic break and not be absolutely psychotic in every way, but it's very, very noticeable when one has what psychiatrists and psychologists call a psychotic break. It's very noticeable both to professionals and to non-professionals around the individual. Everyone, in my opinion, any reasonable person would know something was very wrong.
Did you see any evidence of that with the defendant around the 19th, 20th of July, 2012?
Objection asked and answered.
This is a little different. This is more specific than the last question asked. Overruled.
I saw no indication of that. There is an action, namely the violent action, that's quite unusual, but that it's simply the evidence for a psychotic break, something acute like that, is just not there.
And so let me jump forward now, sort of backward to the question I asked, which is, can you tell us what findings you made that helped you come to your opinion about whether the defendant had the capacity to know right from wrong based on the standard the court has advised the jury of?
Sure. There is lots and lots of evidence with regard to his having the capacity to know that the shootings would be highly illegal. There is no evidence that I know of that suggests that he didn't have the capacity to know that the shootings would be highly illegal. His planning, rehearsing, practicing were hidden from others, surreptitious. He planned and considered and or implemented various methods of distraction or escape. He carefully chose a method of killing that he reasonably believed would result in maximum death with minimum chance that he would be stopped before shooting and killing many people. He carried out the shootings and related behaviors deliberately and methodically. He knew beforehand that his victims would suffer and that they would not have wanted to be shot or killed. A couple of other things have come to mind since I wrote the report that kind of overlap with this. I see no indication in the record that he was particularly disorganized in his activities around that time.
Hang on one sec. You got
Sure.
to tell us what that word means. What does disorganization mean, and why is it psychiatrically significant?
His thinking, although odd in some ways, was not disorganized. It was a rational, he went through rational steps to accomplish the task. The reasoning he used in accomplishing the task was generally deductive reasoning, if you will. If I do this, such and such is likely to happen. If I do that, something else is likely to happen or not likely to happen. Those are counter to the thought that he was psychotic and out of touch with reality.
I want to ask you a couple follow-up questions on that. You said that one of the things you considered was that his planning and practice were surreptitious. What are you referring to?
He didn't tell his doctors about many, many aspects of the things that would have been important to tell them. He didn't let anybody see what he was doing in his apartment. He didn't talk with anybody about his plan when he, in his words, cased the theater. As far as I know, he didn't tell anybody what he was doing. He didn't tell any of his friends who asked how he was doing at various times and how was he. Didn't tell any of them. This was a part of his life, unlike other parts of his life at the time, that he very much kept to himself, I believe, for the specific purpose of being allowed to continue it and not being stopped.
How about when you said he had methods of distraction and escape?
His cell phone ruse, that is, he figured out a way to be able to leave the theater without drawing attention to himself by pretending he got a cell phone call so he could go outside and put on his regalia, his body armor, etc., and get the weapons. He chose, by the way, not to walk through the theater wearing the body armor and the weapons, although I think he had some sort of leg protection underneath his pants. He excuse me, parked his car behind the theater. He had some general ideas of what he might do to escape, but I want to be clear that he has consistently said that he didn't plan very much at all beyond the killings. He wasn't planning to run off somewhere as far as anybody knows, but he did have a couple of things in his car that were consistent with the possibility of escape. Those are things that come to mind. There are probably others.
What about the venue that he chose to commit these murderous acts?
He talked a lot with me and with others, and in his notebook, about choosing a place that was contained, that would have lots of people in it at a particular time, in which before the police got there, even though the police station was close, before they got there, he could kill some people. He thought about other kinds of venues and eliminated them for rational, or at least pretty rational, reasons. Don't want to make a bomb because they don't know how to make a bomb. Don't want to do it at an airport, for various reasons that he jotted down. So that within that task, he chose the venue, the time, etc., carefully.
What about methods to incapacitate his would-be victims?
He purchased and used some tear gas or a tear gas-like material to both protect himself and incapacitate the victims. He had a plan to lock one of the escape doors with handcuffs. He didn't carry it out. He planned to do that and purchased the handcuffs. He specifically didn't want people to escape and kept them from escaping by shooting them or shooting at them. I'm not thinking of other victim incapacitating things.
How about the decision to cover himself head to toe with body armor?
It's clear that he decided to do that and rationally carried out ways to do that, ordered the materials, tried them on. They were the kind of materials, I think, that a rational person would buy, although I'm not a criminologist or a ballistics expert. He described, and I can think of at least two reasons for that. One has to do with protecting himself so he doesn't get killed. Another has to do with surviving long enough to kill more people.
What about this notion that he wanted to keep it, in his words, impersonal?
That description, to me, is not a reliable description. I don't know exactly what's in his mind. As he says that, no one can know what's in his mind. When I asked him about other ways of killing people that might cause more deaths and less collateral damage, for example, sniping or ambushing people, the fact that he said that was too personal seemed odd to me, since in order to carry out the theater shooting, he moved through the theater with lots of people around, sat among people. When he came back in, was aware that at least some of the time, I don't believe all the time, but at least some of the time, he was aiming at specific people who were doing specific things that he didn't like or didn't want to occur, such as leave. When he talked about the person who was apparently emptying the trash into a trash dumpster while he was changing in his car, he said, or strongly implied, that he was willing to kill that person. Actually, he didn't say kill that person. He said there was a gun for that purpose in the door of the car. That would have been, in my view, pretty up close. And I think I asked him about that being what I called up close and personal, so that whatever he may have meant, there were some close attributes to that. Perhaps I'm not saying that very well.
If we're to take the defendant at his word that he believed that he would increase his value by murdering more people, does that impact at all your opinion about whether he knew right from wrong based on societal standards of morality?
Objection asked and answered.
Sustained.
How about the fact that he says, subsequent to being arrested, that he believed that he would have possibly committed suicide if he hadn't murdered all these people? Does that impact his capacity to know right from wrong based on societal standards of morality?
It doesn't suggest to me an impact on such a capacity. It may be a belief that he had, it may be, but it doesn't say anything to me about his capacity to know right from wrong.
The other part of this sanity standard that the judge has read involves the capacity to form the intent to kill after deliberation and then to act knowingly. Now, there may be some overlap with some of the things you've just described, but are there additional things that you considered that were factored into your opinion about his capacity to form the intent to kill after deliberation and to act knowingly?
Objection asked and answered.
I think this is a different question than what was asked before, so overruled.
It's very clear to me that he had the capacity to form that kind of intent and the capacity to know those things. I just don't see any indication that he did not.
Would you, in your expert opinion, characterize the evidence that speaks to his capacity to know right, bless you, know right from wrong, and his capacity to form the intent to kill after deliberation and to act knowingly?
Sure.
Leading.
Overruled?
Sure. There's so much of it. There's so much evidence in that direction, in my opinion, that I could talk about it or read things for a long time. Generally, pretty much everything I've said goes to that, plus his own statements 2 years later. We need to remember that those statements were 2 years later, that he was aware of what society thought and believed, and that it was worth it to him for the things he thought he would get out of it, namely 50-50 chance of being less depressed, at not committing suicide, and the additional points to increase his value or his feeling of value. They were, I think he stated very clearly, they were worth it in spite of what he described as a capacity to know what society thought about that.
Objection, that misstates the evidence.
Members of the jury, I remind you again that you have to rely on your own memory of the evidence as opposed to this witness's recollection of it.
Thank you, Your Honor. Beyond the statements that you talked about, which admittedly were 2 years after the fact, did you consider in formulating these opinions the other evidence that took place before and even after July the 19th and 20th, 2012 in coming up with your opinion?
Sure, and that evidence and pieces of the record, et cetera, from before and just after are important. They have to do with his conversations with other people, his conversations, for example, with Gargi, I believe, his girlfriend at the time, and then his friend for some time after that, about waiting until he was old to kill people because you get arrested for that, or that means your life is over, or something like that. I take into consideration reports that I read of people who saw him soon thereafter, interviews that I read or are viewed on video of him, comments from people who were around him in in June, and I believe also in July, Dr. Fenton's comments as of up to June 11th, things like that.
If someone else were to disagree with your diagnosis and say, I think that the defendant suffers from something called schizoaffective disorder, would that change your opinion about his capacity to know right from wrong and to be able to form the culpable mental states in this case?
No, because everything I've described is simply something that he did or was able to do, no matter what his diagnosis was.
Even if that diagnosis was schizophrenia?
Even if his diagnosis was schizophrenia.
At the end of the day, are the things that you relied upon to form your opinion about the diagnosis or the defendant's ability to function?
I'm sorry.
Your opinions.
Oh, are they about diagnosis or ability to function? With regard to my task with the court, it's about his ability to function.
Doctor, within a reasonable degree of certainty in your areas of expertise, was the defendant legally sane under the standards the court has given you on July the 19th and 20th of 2012?
Without meaning to usurp the jury's job, and it's a tough job, I believe so.
May I have a moment, Your Honor?
You may.
I have nothing further, Your Honor. Thank you.
All right, cross-examination, Mr. King. Take your time.
Afternoon, Doctor.
Hi, Mr. King.
I don't know if I'm going to be done with you by 5 o'clock.
I understand.
But before we play all of the videos again for the jury, I have some questions for you.
Surely.
What I'd like to do with the time that I have remaining this afternoon and tomorrow morning is I'd like to, with your permission, sir, do the following. I'd like to have a discussion with you about the way you approach this examination, if I may. I'd like to have a discussion with you about your qualifications and experience, if I may. I'd like to talk with you about mental illness or disease generally speaking. And more specifically, I have some questions about the schizophrenia spectrum disorders and other disorders that are diagnosed by the various clinicians in this case. And then finally, I'd like to talk with you about some of the conversations you had with Mr. Holmes and the things that he said, and follow up on some of the points that Mr. Brockler has raised with you over the course of the past week or so. Is that okay with you?
Sure.
I would first like to talk about two kind of general topics that apply here, if you will. And the first of those is malingering, and the second is memory. Malingering, sir, is the feigning of psychiatric symptoms. Is that correct?
It's the feigning of pretty much any symptom or medical symptom, including psychiatric ones, with the specific intent of gaining something. There's another condition in which you feign without that, but I understand what you're saying.
And with regard to malingering and gaining a benefit, you're talking about, as an example, what an example might be somebody who's seeking to get declared so that they can receive SSI or some kind of support for being disabled along those lines due to a psychiatric condition. If you were to evaluate someone who is in that position, you would want to bear that in mind, that there was that possible motivation there. Is that right?
Yes.
And malingering, or the feigning of symptoms, is something that all clinicians have to be concerned about in all circumstances, right?
To some extent, particularly, and we're taught particularly when there's a gain to having a diagnosis or the symptoms.
And I gave one example of that. Certainly another example of that might be if someone was facing criminal charges.
Sure.
And it would depend on what they desired the outcome to be, obviously, but there may be, in that circumstance, a concern that the person might be feigning symptoms, faking it, in order to gain some kind of benefit in court. Fair to say?
Fair enough.
Now, even people who have mental illnesses can malinger. Isn't that right? Sometimes people may have a mental illness, but they may exaggerate it. Fair to say?
Exaggeration may be a little different from malingering, but it's certainly true that people with mental illness sometimes malinger or attempt to malinger.
And the way that you guard against malingering, and as a forensic psychiatrist, and I'm going to go through that in a while, but your specialty is forensic psychiatry, correct?
Correct.
And that has to do with the intersection of psychiatry and the law. Fair to say?
Fair enough.
You're trained especially in doing what you're doing here today, testifying in court about legal matters for judges and juries. Fair to say?
It's one of the things that I do. I don't spend much of my time doing it, but it's one of the things that I do.
You, and the way that you guard or against a possible malingering in that context is that you really have to be very vigilant about it and keep your eye open for it all the time, right?
That's one of the things, sure.
You have to match what the person says to what the person says to other people, correct?
That's one of the ways to guard, yes.
You have to compare the person's descriptions to other evidence in the history or in the case itself that would either corroborate that testimony or those statements or contradict it.
If it's available, yes, it's a great idea to do that, and I recommend it.
And I'm going to talk to you about statements that are made and memory in just a while, but I'm trying to focus just on this area right now as I go through. And the way that you as a psychiatrist normally do this, and correct me if I'm wrong, is twofold. You in the course of your clinical interviews and your interactions with the patient or the defendant, you employ your clinical experience and your training to make an evaluation of what you think is the situation with regard to whether the person is malingering or feigning symptoms, right?
That's part of it. It's not the most reliable part of it, but that's part of it.
And another reliable part of it is that you can engage in psychological or neuropsychological testing that will test for effort and feigning, correct?
There are some tests, particularly for feigning, for some disorders, and there are a number of tests in which a part of the test has to do with whether the test is taken honestly with appropriate effort, yes. And you may have misunderstood an answer that I made earlier, and forgive me if you didn't. When you asked about using one's clinical experience in the interview, one of the things I said was that is not the most reliable thing. It's useful, and I just wanted to be sure that you didn't class that as one of the super reliable things.
No. What are the super reliable things that you're referring to then?
I wish there were ultimately reliable ways. They very often have to do with, perhaps most important, corroborating information, seeing if what the person says comports accurately with the person's medical record, with observations of other people over time, with information from a time in which the particular question didn't matter, such as before a crime or such as before. I don't want to go on too long, but you get the point.
And forgive me, but I thought that's what I was asking you about when I asked you about corroboration and the changes in statements. Is that the kind of thing you're talking about now?
Yes.
And my question then was, you view those things in light of your own clinical experience as an experienced psychiatrist, correct?
Sure.
When it comes to the psychological testing, that's not something that you do yourself as a regular matter. Is that right?
I don't personally do testing. I refer it elsewhere, and although I'm familiar with some tests, if we get much further in questions about that, I'll ask you to ask a psychologist.
And I think we're going to have an opportunity to do that. But just so that we're clear, that's fairly normal for psychiatrists to not themselves administer psychological testing. That really is more often the purview of a psychologist, fair to say?
That's a true statement.
And the difference, again, and I think Mr. Brockler may have touched on this, but the difference between a psychologist and a psychiatrist, well, first of all, they're both mental health professionals.
True.
They both treat individuals with mental illnesses.
The clinical ones do, yes.
They both can diagnose mental illnesses.
The clinical ones, yes.
Depending on their credentials, they can render opinions about sanity or other opinions, fair to say?
Fair to say.
And the one thing, well, not the one thing, but a significant difference, certainly, is that psychiatrists such as yourself are MDs, right? Medical doctors.
That's correct.
That means you went to medical school, as we know, and then you decided to specialize in the area of psychiatry, correct?
And then took further training in that. That's correct.
So you had to go through all of the normal training that every other doctor goes through to get by medical school, and then you went on for further training in psychiatry. Is that accurate?
Yes.
And a psychologist is someone who doesn't have an MD but has a PhD normally.
Most clinical psychologists, those practicing and licensed to practice in states that I know of, have doctorate degrees, PhDs, yes.
Some have a thing called a PSY.
There's a PsyD, there's an EDD, but they have a doctoral level training and often an internship in the clinical aspects of psychology.
And I don't want to, again, get too in-depth to these psychological instruments or tests that are given, but these are things that are normed very often, are normed statistically against the general population. Fair to say?
The good ones are normed, that is validated. They're tested against members of the general population, often also against members of a particular diagnostic group or members of a particular cultural group or legal group, such as people in prison or people with depression, something like that.
And many of these instruments, like the MMPI or the PAI, and I'm using acronyms, or the SIRS, SIRS, are normed to the populations, and that's in order to provide an objective measure, in a sense, of how that person's testing relates to others in the population who may or may not have a mental illness.
I think it's fair to say, and I'll try to stay within my expertise here, that the effort is to take group data and accurately apply it to individuals where one can.
And in this case, involving Mr. Holmes, you did both of those methods, I guess, of testing for whether he was malingering or not. Is that right? And by both, I mean you both engaged with him over a long period of time, took statements from him and evaluated, in your opinion, those statements and et cetera, correct?
Correct.
And you also farmed out, if you will, to a psychiatrist and a psychologist and a neuropsychologist, actually, from the Colorado Mental Health Institute in Pueblo to do both psychological and neuropsychological testing for you. Is that right?
I asked for the psychological testing, including some testing specific to malingering. I don't believe I asked for the neuropsychological testing, but it was done.
Yeah, but you got the results of that.
Yes,
testing.
I have the results.
And that was done by Dr. Rose Manguso, is that correct? The neuropsychological testing?
Among other people, yes.
And the psychological testing that you asked for was done by a doctor named Dr. Thomas Gray from Pueblo, is that right?
Yes.
And Dr. Gray administered the instruments I just named, amongst a few others, the PAI, the MMPI, and the SIRS, and I'm going to let him describe what the details of the personality testing is, but I just have a couple questions about the SIRS in particular.
Sure.
That was something that you requested, correct?
It was suggested to me, and I would have requested it anyway. It's pretty standard in a situation like this.
And what the SIRS stands for, the acronym stands for Structured Interview of Reported Symptoms.
Yes.
And that, again, is a test that's normed up statistically against a population. Is that right?
Against various populations in various contexts, yes.
And that's a test that's actually written by Dr. Richard Rogers. Is that right?
Yes.
And Dr. Rogers is a very highly regarded psychologist. Fair to say?
Very fair to say.
And that's someone that you know.
I've known him for years, yes.
And that SIRS test basically is a test of whether or not someone is malingering the symptoms. They're asked to endorse certain symptoms, and they either do or they don't. And then the test can tell through proper analysis objectively whether or not the person is feigning their symptoms.
I think it'd be more accurate to say, and I may be corrected by Dr. Rogers or Dr. Gray or somebody else, that the test attempts to gauge the probability that a person is feigning answers on that test. Not that he's feigning answers somewhere in a psychiatric interview, but that the person is taking that test accurately and honestly.
Right. So
the result that comes out, I believe, is a probability statement, something like, this is the group in which the likelihood is high, this is a group in which the likelihood is medium, and this is a group in which the likelihood is low, or something like that.
yeah, and we'll have the psychologist describe exactly how the statistics work.
You're exhausting my knowledge as
But
we speak. Yeah.
suffice it to say that, like you said, the test only can evaluate the items listed in the test. It can't go out and check everything else that took place in a psychiatric interview, for example.
That's right. It uses those items to make an estimate of the way the person is answering questions at that time.
And you end up with a percentile score of where the person falls among the statistical population.
Something like that.
Your conclusion, after employing these methods, sir, in this case, is that Mr. Holmes there is just no evidence that Mr. Holmes is malingering that you've encountered.
There at least is very little. I think the likelihood is very low. And if I might just make a quick statement about malingering, that I think, I don't know what's relevant or not. You're speaking about malingering illness or illness symptoms. In occasional situations, there are people who wish to malinger being better than they are. They wish to try to appear better than they are. I don't think it's relevant here, but I just wanted to be complete in my answer.
Okay, so that would be understating your symptoms.
Yes.
Or hiding your symptoms, perhaps.
Yes.
You, as you sit here, cannot think of a reason that you think, let me say this. There is very little, if no, evidence that Mr. Holmes is malingering. Fair to say?
In my opinion, that's correct.
And that's also the opinion of all of the other clinicians that have evaluated him, as far as you know. Is that right?
Who have evaluated him, you're correct so far as I know. Mm-hmm.
And the opinion of Dr. Gray, after administering the SIRS, was that there is virtually no possibility that he's malingering based upon that instrument.
You'd have to ask Dr. Gray. I have his report somewhere, and I don't remember exactly what he said. It was along those lines.
Nothing that caused you any concern at all.
That's correct.
So there's certainly, you said, very little, if no, evidence that he is malingering, and there's ample evidence that he is not, correct?
I think that's a good way to state it.
I also want to talk to you a little bit about memory, if I could.
Sure.
And the reason that I want to do that is because you came on to be involved in this case after some period of time had passed since the July 20th, 2012, correct?
Correct.
Do you recall when you came on board?
It was
approximately
spring of 2014, late spring of 2014, I believe.
So that's 2.5 years after the event, correct?
At least 1.5, 1.75 years.
There we go. That's why I went to law school, right? So at 1.5 years when you came on board, and a little, right around 2 years when you started doing your, the videotaped examination that we've just seen.
Right at 2 years later.
And you had access to a lot of information in the history, and we're going to talk about that. But all of the statements that you received from Mr. Holmes were taken after that 2-year period had elapsed, correct?
I'm trying to think if there were any quotes from prior to July 19, 2012.
Well, I'm talking specifically about things he said to you
Oh,
personally.
yes, those were all 2 years and more after the fact.
Other than the things he said to you personally, you're relying on the reports of other clinicians or other witnesses or other documents that are providing you with the history information,
It's at least secondhand.
at least secondhand.
Except, I hate to be so obsessive about it, there was a videotape when he was an adolescent that he was in. I don't think it matters to your question.
There was a videotape that we gave to you also when he was in the hospital, right?
That was well after the fact.
That was
Yeah,
after
I'm talking, oh, yes.
And I'm talking about any statements that the defendant made to you, and all of the statements that the defendant
me,
made to you
it's
were
all
made
2 years
2
out.
years afterwards.
Yes, sir.
And at that point in time, he had been seen Dr. Gurr, correct?
He had seen Dr. Gurr by that time, yes.
And Dr. Gurr had seen him a number of times at that point. Is that right?
I believe she'd seen him at least twice. I'm not certain. I could look at the record, but yes, she had seen him and interviewed him for, I think, a number of hours.
Okay. And she saw him, for example, December 19th of 2012.
I know she saw him soon after the event of November of 2012. As you're speaking, I believe she saw him in later December and then in January of 2013.
Saw him in January of 2013, and then she saw him in February of 2013 again. Is that right?
I imagine you're accurate. I'm just not remembering the particular chronology.
And my point is not the dates. My point is that she saw him several times before you did. Fair
That's
to say?
accurate.
He also was seen and evaluated by a psychiatrist named Dr. Jeffrey Metzner before you saw him. Is that right?
That's correct.
And we presumably will hear from Dr. Metzner at some point too and what his opinions are. You've had an opportunity to speak to him. Is that right?
Yes, I have.
And you've had an opportunity to speak to Dr. Gurr as well. Is that right?
Yes, I have.
In addition to, and both of those doctors conducted clinical interviews with the defendant,
Yes.
with Mr. Holmes, that they, and they may have different styles than you do, but they talked about the topics, many, if not all of the topics that you discussed with him.
Fair to say.
Also, Dr. Robert Hanlon, a neuropsychologist retained by myself, by the defense, did neuropsychological testing on Mr. Holmes, right?
Yes.
And that was before you saw him.
Yes.
And as part of that, Dr. Hanlon conducted a clinical interview with the defendant where he talked about many of the issues, probably not in as depth as the psychiatrists have, but he talked about many of the issues relevant to this case that you've discussed.
As is routine, interviews and then the testing, sure.
And it's routine for psychologists to do that. They're not going to just do the test blind. They're going to review the history like you review the history and conduct some kind of a clinical interview.
In situations like this is routine.
So in addition to Dr. Hanlon and Dr. Gurr and Dr. Metzner, and Dr. Metzner saw him a number of times, is that right?
I'm not certain how many times, but I believe you're correct.
In addition to those clinicians, we had Doctors Manguso and Gray conducted testing at Dr. Metzner's request, correct?
That's correct.
And both of them conducted clinical interviews of Mr. Holmes.
I know at least one of them did, and if you say both, I'm sure you're correct.
Okay. So suffice it to say, by the time you got the opportunity, and I'm not faulting you for this, certainly, by the time you got the opportunity to speak to him in July of 2014, he'd already been seen by several other clinicians, fair to say?
That's true.
And so the topics that you discussed with him had been discussed with him several times.
I'm sure that many of them had. I can't say that that all of them had. I suspect there are a few things, or some things that I asked him that others had not, but I'm sure that many other people had asked lots and lots of questions on lots and lots of topics.
Sure. Suffice it to say, there might have been questions you asked that they didn't, right?
Mm-hmm.
Might have been questions that they asked that you didn't.
Yes.
And so my question is this. You have expressed some ambivalence, let's just say, about some of the psychiatric issues in this case. And let me just point out a couple for you. You've described today your feelings about the human capital delusion, I'll describe it as. And you've described that you are still a little unclear on whether you think that's really a delusion or not. Fair to say?
Fair to say.
You said that it's certainly consistent with the delusion. Many of the things he says are consistent with a delusion. Is that right?
Consistent with, meaning that it does not dissuade one from that, but in my view, does not necessarily diagnose it either.
That's a good point. And why don't we digress just a minute and talk about that? Because during the course of Mr. Brockler's examination, you many, many times used that phrase, that it was consistent with or inconsistent with the capacity to understand the difference between good and right and wrong, for example. Correct?
I probably did, and when I say consistent with, that's exactly what I mean. It doesn't define it, but it doesn't pull one away from it. It doesn't mean, it's not inconsistent with, if that's clear.
Sure. So it's consistent with it, meaning it could indicate that, fair to say?
With other supporting material to go along with it, it could indicate that, sure.
When we're talking about any specific statement or any specific piece of evidence, when you say, well, if he said this, that's consistent with capacity, what you're saying is it's relevant to it, but not dispositive of it. Fair to say?
That's a good way to put it. Sometimes if I'm talking medically, I've got a stomach ache that's consistent with stomach cancer, but you don't diagnose stomach cancer just because you have a stomach ache.
Right. And you know, having an earache could be consistent with having a sore ear, or it could be consistent with having cancer or something like that, right?
I suppose so.
So when you say that Mr. Holmes' statements or behaviors are consistent with capacity, that's exactly what you're expressing.
That anytime I use that word, that's what I'm expressing.
And when you talk about diagnoses beyond a reasonable degree of psychiatric certainty, I think was the phrase, to you that means more likely than not, right?
That's what I understand the court means by that phrase, and so I adopt that. If I'm in error, somebody will correct me, but that's usually the case.
Yeah, and so that's more likely than not is like 51% then, right?
It can be just 51%, or it can be 96%, but it needs to be at least a little over 50%.
Now, the part of the reason, if not the entire reason, that you have some ambivalence, and another issue that you said you had some ambivalence about was the paranoia issue, for example. Certainly you testified that could be consistent with someone just trying to avoid getting into trouble, right?
In other words, it wouldn't be paranoia, yes.
It also could be consistent with a paranoid delusion, fair to say?
Depending on the situation, and I'm not referring to anything specific here, yes.
And we'll talk more about what specific examples possible paranoia, but that's an area where it could be consistent with one thing, it could be consistent with something else, and it's very difficult for you to actually pin it down.
In some cases that's true, and in some cases there are surrounding factors that do allow me to zero in a bit more in the big picture.
And in this case, you're constrained by what was available to you, the information that was available to you. in terms of the history and when you were able to actually discuss the matters with Mr. Holmes.
That's true.
And for that reason, well, let me ask you this. If you, let's say you had all the time you wanted. Let's say you were told you can go and talk to Mr. Holmes all day, every day, for as long as you want. Do you think that would ever bring you closer to having a concrete diagnosis?
It might, and I'll tell you why. I would then be talking about a diagnosis at the time that I'm seeing him, not about the diagnosis back in July of 2012. So, given the ability to watch Mr. Holmes' course of illness or course of life over the next many years, there may be things that indicate or detract from the idea that today he has a certain diagnosis, but we're always we're not talking about going back to July 2012. In my opinion, I can't think of anything additional that we could do today that somehow takes a time machine back to then.
Okay. And I want to parse those out if I
Sure.
could. In terms of moving forward with a diagnosis about what his mental illness is, you testified, I think earlier today, that it's not uncommon for different clinicians to have different opinions about what the possible diagnosis might be. Is that fair?
It's not uncommon, but I want to be clear, and I think it's relevant here, and it's in my report as well, that I would be surprised if different qualified clinicians, psychiatric clinicians, differed very much. I would be surprised if someone said Mr. Holmes' diagnosis is a brain tumor or Mr. Holmes' diagnosis is Alzheimer's disease. So that everybody seeing roughly the same information, but seeing him at different times and maybe asking different questions and getting different answers, slightly different answers. I don't think they're markedly different. The diagnoses may differ a little, but I want to make it clear that we're all in the same, in my opinion, in the same ballpark.
And I'm going to get to that too. And what you're saying is, with regard to this case, you think the diagnoses are all really in the same ballpark. Fair to say?
If you're talking about ballpark, yes. Maybe not on the same section, but at least in the same ballpark.
And let me bounce this off you and see if this makes any sense at all. In my opening statement, I made up my own analogy, and I compared it to going to buy paint, trying to match some paint in your house. And I described for the jury going to the paint store and saying, this is some red paint I've got in my house. I need to match this red paint. I need some red. And the person who's the expert, the paint expert in that case, might say to me something like, well, that's actually more like a brick or more like a scarlet. Or do you get or a rose, to get my point? That those are all reds, but there are different types and variations. Is that an apt description?
I think that's a pretty good analogy. We would pretty much all probably agree that he's some shade of red. He's not yellow. But I don't want to take the analogy too far, okay? He's a human being too, and human beings are more complicated than colors.
Very much so, and we'll talk about that as well. So with regard to the moving forward and with the diagnosis, and if you had all the time in the world, you don't know. It's possible that it may turn out that you're wrong, right? And that he does have schizophrenia, correct?
Speaking in the present tense, that's accurate. I don't think that anybody can go back to 2012 and say, with authority, in my opinion, Dr. Reed is wrong, Dr. Gurr is wrong, Dr. So-and-so is wrong, because that's set in 2012 based on what was going on back then.
Right.
With that caveat, I think you're right, and I think you're right.
So then with the other part of that comment, not moving forward in terms of diagnoses, but looking back and trying to determine what was going on 2+ years ago, that's what you're saying is what you have are statements that are made 2 years later to you about an event that took place 2 years ago. Fair to say?
If they're coming from him, that's exactly right, and it's important for the jury to remember.
And you've said that a number of times to this jury, that it's very important to remember that this is 2 years later. Is it also important to remember that Mr. Holmes, when you talk to him, is in a somewhat medicated state, that he's taking antipsychotic medication?
He's taking a relatively low dose of medication, the antipsychotic, a little medium dose of the antidepressant, but that is certainly a consideration. And he was not taking medication on the days of the shooting. Now,
is memory something, are human beings' memories like videotape recordings? In other words, do we, when I recall something that happened in the past, am I 100% correct? Well, I may be 100% correct, but let's use other people. Is anyone 100% correct when they recall a memory?
With the exception of people who have what's called eidetic memory, people with the truly photographic memories, where they're very, very rare. Memory is a dicey thing. There are lots of things that affect memory. Time is one of them. Let me just stop there.
Do memories, does the number of times you're asked to recollect something affect someone's memory, perhaps?
It can, sure.
How?
For one thing, memory is a bit fragile and malleable. And let me say at the outset, I don't purport to be a true expert in memory. I work with memory a fair amount, and I read a bit about it because it comes up in situations like this. There are true memory experts, and I'm happy to refer you to those. Having said that, I've talked so much I've forgotten the gist of your question, please.
Okay. You were saying that it's malleable, and I was asking you how.
Sure. Memory can be changed, sometimes rather easily, by the person's accepting something false as if it were true about the past. One example of that, I'll take it one end of the spectrum, is when someone is hypnotized, you can very easily and sometimes accidentally insert a memory of something that is a true memory but not accurate with regard to the past. If we take that out of the area of hypnosis into the area of simply paying a lot of attention or believing what someone says, or even wishing really, really hard, and over time, finally, it becomes part of your memory. What I'm trying to convey, and not necessarily about Mr. Holmes, what I'm trying to convey is that memory is not like a videotape. It is not something where you can go in and put a little electrode on this part of the brain and get an accurate memory. What it is what the person recalls as accurate, and it may or may not be accurate.
And you've spoken to me about this when I asked you to explain the 2 years, and I didn't dream this up. I'm getting this from you. Is that right? We discussed memory.
We've spoken before, and I think we've spoken about memory.
And probably every time that someone remembers something, it might change a little bit. Fair to say?
It may change a little bit. You say it some way, and you hear yourself say it, and gosh, the fish gets bigger, or the stream gets faster, or something like that. Bear in mind, I'm speaking generically and not about any particular situation.
Right. We're not specifically talking about Mr. Holmes. We're talking about every human being that's alive, right?
Except for those with eidetic memory, yes.
And the number of times that if it's malleable and can change when you're asked to recollect it, then the number of times you're asked to recollect it can affect that. True?
It may affect it. It doesn't always, but it may affect it.
Now, memories, and I'm going to ask you to explain this, I guess, but memories human memory also tries to make sense of things so that there's less anxiety and confusion, right? Human beings don't like anxiety and confusion, right?
That's right.
And so when we remember things, we very often can confabulate in order to make it less anxious or confusing to us.
That's an accurate statement, and I want to convey that this is an unconscious process. It's not something that something does on purpose. Our psyches don't get along well with unsettling things and certain strong emotions or things that cause us anxiety, as you pointed out. And I think we all, in one way or another, in some way create our past so that even though we may remember it as a bad past, it's something we can live with.
Now, Mr. Holmes, in recollecting things to you, well, the fact that he's not denying playing a role in the shootings is significant to you, right?
I think that's significant.
And the bottom line is that it's important to note that Mr. Holmes, in the videotapes, is being asked to remember how he was thinking some 2 years ago when he wasn't medicated as he is now.
And various other things have happened also in the interim. You're correct.
Now, you asked Mr. Holmes about when he was arrested and when he went to court the first time. And he indicated that he didn't have a lot of memory about that. Is that right?
Yes.
Your opinion is that the way it comes out with Mr. Holmes is the way that people generally describe things to other people over the years.
I'm not sure I understand.
I'll strike the question. You point that out to him in the video interview on page 269 of the transcript, and you're welcome to look at that if you want. I have a copy for you. But during that exchange, you point out to him that you say we should remind people and whoever watches the video that we're talking about something that happened 2 years ago, comma, when you were in a very different state of mind than you are today. Correct?
I recall saying something like that, yes.
And I want to talk to you a little bit about that state of mind briefly here in the time that I have left this afternoon. Your opinion here is that, well, let's go into, there's some variation, as you said, in the different diagnoses that the clinicians, the examining psychiatrists have given to Mr. Holmes. Fair to say?
Fair to say.
You've diagnosed him with a schizotypal personality disorder and possible delusional disorder, correct?
Correct.
Dr. Metzner, who's another court expert, diagnosed him with a schizoaffective disorder.
I believe you're correct.
And Dr. Gurr, the defense expert, had diagnosed him with a schizophrenia, correct?
That's correct.
And when you describe these all being red, to use my analogy, what you're referring to is that these are all disorders, mental illnesses, that fall within what's called the schizophrenia spectrum of disorders under the DSM-5.
Yes. Psychiatry in general and psychology, clinical psychology in general, and the DSM-5, keep these things in the same section. They speak of them as related, not necessarily on a continuum, but in the same general area. They're mentioned in the same section. The criteria for schizotypal personality are in another section, but the mention of schizotypal personality is in the same section as schizophrenia, schizoaffective disorder, and some other disorders that are all serious.
And you said, I think you just said about 10, 15 minutes ago that we have to bear in mind that all of the clinicians saw the same person, the same James Holmes, maybe at different times and with different degrees of memory or not, but it's the same person, correct?
They all saw him well after the event. All the people you just described saw him well after the event. Dr. Fenton, Dr. Feinstein, I don't think you mentioned, they're a little different, but saw him after the event. It's a little like the old proverb, you never step into the same river. It grossly is the same river, but it has different characteristics at those times, sure.
Now, Dr. Woodcock, who's a defense psychiatrist and neurologist, actually saw Mr. Holmes just a few days after the shooting. Is that right?
Yes.
And to your knowledge, he's the only clinician, other than Dr. Fenton and Feinstein and Roth, who saw him in an unmedicated state. Fair?
Unless Dr. Sather did, but in general, you're correct. I'll stand corrected if Dr. Sather did.
And Dr. Sather, so that we know, is the psychiatrist who's assigned to treat people in the jail. Is that right?
One of them, yes.
He didn't evaluate Mr. Holmes, or his purpose was just to manage his care.
That's my general understanding. And
He didn't render any opinions about the diagnosis or the...
I don't believe so. Are you referring to Dr. Sather or Dr. Mosier, because he was also involved with the jail?
Right. Maybe I'm confused. One of them's a psychologist and one's a psychiatrist, but they both work at the jail. Fair to say?
I believe Dr. Sather is a psychologist. I could stand corrected. I know that Dr. Mosier is a psychiatrist.
I think you're right.
Okay.
Thank you. Thank you for correcting me. And you even state, and you said this before, and you say this in your report, that it may turn out that the diagnosis is in fact schizophrenia in the end. And if that's the case, what you're describing would be the prodromal period of that.
If he is clearly schizophrenic today or sometime in the future, then my diagnosis would have to do with, very likely, a prodromal or a pre-version of that, whether you call it schizotypal personality or whether you call it pre-schizophrenia.
That wouldn't be a tremendous surprise to you if that were to happen.
No.
So you don't describe any disagreements that you would have with Dr. Gurr or Dr. Metzner as being like a knockdown, drag-out fight over the diagnosis. You're all in the same area.
I think we might have vigorous discussions about pieces of that. I don't want to say that we're that close, and we're all friendly, I'm sure. But to me, it's not a knockdown, drag-out fight.
And I'll talk to you about how important it is to you too. But when we talk about all of you describing the same guy with the same problems, not everyone's individual disease is the same. Is that fair to say? So not every person who's diagnosed with schizophrenia is exactly the same as everyone else who's a schizophrenic.
Everybody's different.
Everyone has their own idiosyncrasies. Fair?
Fair to say.
And the fact that a small percentage of people that have serious mental illnesses are involved in crimes or violence doesn't really mean anything one way or another, because it depends on what the nature of their illness is.
That's a good point, and I'll just say gratuitously that it is a small percentage. With the exception of substance abuse, it generally is about the same as the general population, and you're correct.
With regard to Mr. Holmes, you think that probably you and the other clinicians agree on about 90% of the clinical aspects of Mr. Holmes' life before and after this event?
If I use the word 90 or phrase 90% somewhere, I'll stand by it. I'm not prepared actually to quantify it, but something like that.
there's no question in your mind that Mr. Holmes, at the time of this crime, and today, has a severe and chronic mental illness.
That's a true statement.
And that mental illness affects the way that he thinks and the way that he acts, correct?
Correct.
It affects the way he thinks and acts now, and it affected the way he thinks, thought, and act on the 20th of July, 2012.
That's a reasonable statement.
Substantial mental illness existed and it affected his thinking as led up to the events of the shooting, correct?
Sounds like you're reading from my report, and if you are, and I said it, I'll stand by it.
It's your opinion. In fact, may I have a moment, Judge?
You may.
It's your opinion then, and you're aware that and we may go through this a little bit again tomorrow, but you're aware that in Colorado, the test for insanity has what I'm going to call two prongs, I guess. And the first prong is, if you'll bear with me, whether or not the existence of a mental disease or defect, correct?
That's my understanding, yes.
In order to even have a claim of insanity, the first step is that the person has to have a mental disease or defect, correct?
Yes.
And then the second step has to do with the capacity to either distinguish between right or wrong, or the capacity to form the required mental state of the elements of the crime, right?
That's my non-lawyer understanding, yes.
And just to knock it down real simply, your opinion is that prong one has been met, but prong two has not.
That's fair to say.
And given the constraints that we've described already, being the passage of time, the events, memory, you don't really think that it's possible at this time to render a more solid diagnosis than what you have, correct?
That's true if I understand you correctly. The way I framed my diagnosis, and I'll go back and just simply read the way I said it. At the time of the July 20, 2012 shootings, the most reasonable diagnostic consideration would have been, and that's of course in my opinion, that doesn't say it's a lead pipe cinch. But to me, that's the most reasonable diagnosis.
And you don't feel like you can get any closer based on the information that you have?
I don't believe I can. I could sit in a room with lots of psychiatrists and we could hash it over. And I'm not too rigid, I hope, but I don't think I can get any closer than that.
Part of the reason that you gave a diagnosis is that you were asked to do so by the court. Fair?
That's correct.
But in your mind, it's almost less of an important consideration than the capability part, right?
It's not just almost less. In my view, it is less a consideration, substantially less, than the capability part.
Because you've already determined that he meets prong one, so the question then is, does he meet prong two or not, right?
That's my understanding of the question.
And your job, if you will, is to answer the questions that are put before you, right?
Best I can, yes.
There are a lot of questions about this case that are unanswered, right? There are a lot of questions about Mr. Holmes' mental illness that are unanswered.
There are many that are answered pretty well to my satisfaction. There are others that are not answered because he's a human being.
And you focus on the things that are important for your determination, correct?
For my determination, which I view in one sense as relatively simple, in another sense as pretty complicated.
complicated because human beings are complicated, right?
Because all of the things that I need to consider to go into an opinion about that capacity need to be clear to me before I will offer an opinion about that capacity.
And you're careful,
Yes,
and you're not going to overstep what you believe are the appropriate diagnosis.
diagnoses are,
You're not going to diagnose something as 100% concrete when you don't think that it necessarily is.
yes, I try very hard not to either overdiagnose or underdiagnose.
And in the context of conducting this examination that you conducted for the court, you're not Mr. Holmes's doctor, right?
That's correct.
And you explained that to him.
I did.
You're here to fill a limited role.
That's correct.
You're not here to explore and explain every aspect of his illness ad nauseum, correct?
Unless it's relevant to the task that the court put to me, the answer is correct.
And that's was the nature of my question. I appreciate that. You're not trying to treat Mr. Holmes.
No.
You did what you did in order to answer the questions that you were asked to answer.
Yes.
You were asked some questions about whether you worked on other cases in the past. And I think you said that you'd been retained by defense lawyers most of the time. Is that fair?
In criminal matters, that's fair.
And I think you said that was in like 12 out of the 15 cases you testified in or something like that?
Of the ones that have come to testimony, and it gets a little bit mathematical here, of the cases that have been heard somehow in court, I think 12 of those out of the 13 or 14 I've been retained by defense. Let me make one little explanation, again, because I'm kind of obsessive. One of those cases has had 3 or 4 hearings through the years for various purposes. And so that would, I may, in the list that you're looking at, count that as 3 or 4, but they're the same case. Part of the point is, in the past, I've been retained by prosecution in a case that went to criminal trial one time, been retained by the judge, including this one, 2 times.
So one other time.
One of the times, correct. And the other times by defense.
Well, let's talk a little bit about how that works. Does that affect the way you approach your work, who you're retained by?
No, I try very hard not to make it affect my work. Try to do an honest, objective job. And for that reason, sometimes I'm retained by one side or the other, and they don't ask me to come testify because my testimony is not going to help.
There was some talk about, in your direct examination, about the defense hand-picked experts. Are you aware of any other way to pick an expert to work in a case other than hand-picking them yourself? I mean, in the cases you've worked on as a defense expert or as a prosecution expert, were you picked by the lawyers?
Sure, I would expect that lawyers for either side, in a criminal or civil matter, would choose carefully the experts they want to work with. Just
as someone would choose carefully the doctors that were going to do something to themselves or do something to anything that's important. You would want to think about who you pick.
Not a bad analogy.
When you're retained by the court, like in this case, you often get your marching orders from the judge, right?
Yes.
And that's what happened here.
Yes.
And normally they come in the form of some court order or fiat from the judge or something like that?
The judge usually describes, and I haven't had any contact with Judge Seymour, hope I'm pronouncing the name right, but one way or another, orders came to me, here's the situation, here are the questions I would like for you to answer, and those are my marching orders.
I'm not sure if you pronounced it correctly. You did pronounce it without an accent, though, so.
Which is a first.
Which is. In Colorado, I don't know if you know the answer to this, but if you do, in Colorado, those questions that are asked, that you were asked to answer by the judge, are set forth in a statute. Did you know that?
I would expect them to be, yeah.
And the questions you were asked to determine were diagnosis and the issue of sanity, whether or not the person had a mental disease or defect, and whether that mental disease or defect rose to the level where they were rendered incapable of distinguishing between the ability to tell right from wrong or incapable of forming the required mental state, which in this case is intentional with regard to the murder and knowingly with regard to the incendiary devices, correct?
Those were the two main questions that I was asked to address.
Now, when you're retained, and you were, in this case, and tell me if this was true in the other case where you were retained by the court, you're very often, or most often, asked to do a full-blown forensic evaluation along the lines of what you did in this case, correct?
Yes. Yes.
Now, when you're retained by a party, by the prosecution or the defense, that may not always be the case, right?
I suppose, but in my practice, I can't think of a situation where I would accept a situation in which I wasn't allowed to do the kind of evaluation I thought was correct, unless the question asked was narrower.
There you go. Have you been retained to be a consultant before?
Yes.
To one side or another?
Yes.
And in that kind of situation, you wouldn't do an evaluation at all necessarily, right? You just review the history and consult with the attorneys?
It depends on what I'm a consultant for. Sometimes it involves evaluations, in-person evaluations. Sometimes it involves other things.
And as you just aptly pointed out, and I thank you for it, depending on the questions presented or the questions asked of you, it may require different type of evaluation.
It's conceivable. For example, I'm thinking of a matter in which there was a question about whether a psychiatrist on the other side had done an adequate job, and that was the only reason I was asked to participate in the case. But in general, I think it's fair to say when I'm retained by the judge, by the prosecution, and by the defense, I try very hard to do the same quality of job, to ask for the same materials, and to expect getting the same materials that you guys call discovery, things like that.
So what you're saying is when you are retained by the defense or the prosecution, you don't automatically say what they want to hear, do you?
No.
Would that make you useless as an expert if you just say what everyone wants to hear?
We in the business call that being a hired gun. There are less attractive phrases for it too, and we avoid it like the plague.
Have you ever been in a situation where your role in a case changed, where you were, for example, retained to be a consultant and somewhere along the line the lawyers asked you to do something else, to evaluate another doctor's opinion, for example, or to review history in the case and render an opinion about a discrete issue, something along those lines? I think we have an objection.
I wouldn't have stood up that quick, Judge. I object to relevance as to this.
Overruled.
Generally speaking, and my memory may not be terribly accurate with this, if I'm initially retained as a consultant, and there's a difference in definitions here, a forensic psychiatrist or other forensic professional retained as a consultant, as I understand it, is not destined to offer opinions to the court. The latter is someone who's retained as what I usually call an expert. In my experience, in my opinion, once I come into a case as a consultant, it would often be inappropriate for me to then become a testifying expert because I may have done things more related to the side that retained me. As a consultant, I may not necessarily feel the same objectivity to the court as I do if I'm a testifying expert. I hope that's clear.
Sure. But nevertheless, as a consultant, you're not rendering any opinions in court, right? You're not affecting the outcome of the case other than advising the attorneys.
The way I'm thinking of the term, you're correct.
And so, but if you're retained by the defense or by the prosecution to do an evaluation like you did here today, to evaluate someone's sanity and render a diagnosis, you would do it the same way you did this examination, correct?
I would try very hard to do that, and the answer is yes.
And you would do it to the best of your ability without letting any bias affect your work, correct?
That's correct.
And you take that responsibility very seriously, and you would expect other clinicians to do the same if they're not a hired gun.
Yes, I do. Nobody's perfect, by the way. If bias creeps in, we try very hard to avoid that. But that's our aim, and usually we come darn close.
And the fact that there is some small disagreement of diagnosis in this case doesn't lead you to question that someone is a hired gun or not being forthright in their opinions.
The people that you've mentioned, I have as I sit here, no qualms about their ethics and their intentions.
I see the judge looking at the clock, sir, so I'm going to try to break here. But before I do, if I could ask two more questions, Your Honor.
You may.
To sum up, the bottom line for today, sir, with regard to the prong one, prong two analysis is that you feel prong one is met and prong two is not, correct?
Sustain.
And the question is not, did the mental illness affect Mr. Holmes' thinking on July 20th, but to what extent did it affect his thinking and functioning, correct?
That's fair to say, yes.
And it's your opinion, sir, that absent his mental condition, we wouldn't be here at all, would we?
That's a true statement.
This crime would never have taken place without this mental illness.
That's true. In my opinion, yes.
Thank you. I have no questions today. This is a good place to break, Judge.
Yes, thank you. All right, members of the jury, let's go ahead and take our break for the day. We are going to adjourn. And so please make sure you keep in mind all of my advisements related to your conduct when you're not here in the courtroom. Before you leave, I want to remind you that the court has admitted the testimony of Dr. Reed only for a limited purpose. You may consider his testimony only as to the issues that are raised by the defendant's plea of not guilty by reason of insanity. You shall not consider this testimony for any other purpose. All right, have a good evening, folks. I'll see you tomorrow morning. Thank you. Please be seated, everyone. The record should reflect that the jury has exited the courtroom. Is there anything we need to talk about at this time on behalf of the people?
Your Honor, I just want to make sure I remembered the schedule for tomorrow correctly. I couldn't remember if you said we were breaking at 1 o'clock or 1:15 and going to 3 o'clock or 3:15. If you could just help me with that, Your Honor. I seem to have forgotten the exact times.
1:15 to 3:15 will be for lunch, and then we're going to go through until 5:30.
Thank you, Your Honor. And I don't know if the defense has had a chance to look at these emails or if this would be a good time to do that. I can stay if you wanted to do that now.
Okay, let me ask Ms. Spengler. Ms. Spengler, have you had an opportunity to do that? If you would go to the microphone, please. Or give her the microphone either way, I'm sorry.
If I can try to do it without spilling anything.
You may step down. Thank you. We'll see you tomorrow, doctor. Thank you. Ms. Spengler?
Your Honor, I have not had the opportunity to get through all of the emails in order to raise the objections that we're
Okay.
going to make.
I'll give you until tomorrow if you can. Are they going to come up tomorrow?
Well, that's one of the reasons I wanted to do this today. It sort of depends on how long Mr. King takes tomorrow.
Okay.
I have a feeling based on what he said, probably not. But, I know Your Honor doesn't want us to waste the jury's time without having witnesses. So this may be something we would want to do tomorrow, depending on how much time we have.
Okay, Ms. Spengler, are you able to do it overnight?
Yes.
Okay, thank you. All right, we'll chat about it tomorrow. Anything else on behalf of the people?
I don't think so, Your Honor. Thank you.
All right, what about on behalf of the defense? Do you have anything, Mr. King?
No, Your Honor.
All right, thank you. See you tomorrow. The court will be in recess.